Whose face was on the $500 bill in 1918, and how much is that $500 worth in today's currency? Well, that $500 bill would be equal to about $6,500 today. And the portrait that appears thereon is none other than, give me a drum roll, John Marshall. Now we turn to a major case often appearing on the AP US History exam that is considered one of John Marshall's greatest opinions, McCulloch versus Maryland. This case stems from the rapid growth of the United States during the first 2 decades of the 19th century. Our population had doubled in size from 5 million to 10 million. Through the Louisiana Purchase in 1803, our land size doubled as well. Our booming agricultural and manufacturing sectors led to calls for a national currency and a centralized banking system. But this economic growth came at a high price. Land speculators borrowed huge sums for their investments from state banks, which lent money out way too freely. Then the bottom fell out of the real estate market, leaving state banks in a terrible mess and hurting the economy. Oh, wait a minute, that sounds like the real estate crash of 2008, doesn't it? In fact, in 1873, Americans overinvested in railroads, followed by a painful financial crash. In 1929, we did the same with stocks, followed by the Great Depression. These are only a few examples of our boom and bust cycles. Well, back to McCulloch versus Maryland. By 1819, when this case came before the Supreme Court, this financial panic had pitted debtors against creditors and states against the federal government. When the managers of the Bank of the United States tightened credit and began foreclosing thousands of farm mortgages, hard-pressed debtors turned for relief to state legislatures. Several states, like Maryland, imposed taxes on the federal bank's operations. Maryland levied an annual tax of $15,000 on the Bank of the United States. When James McCulloch, the bank's manager in Baltimore, refused to pay the tax, state officials sued him in Maryland courts. Not surprisingly, the state courts ruled against McCulloch, who promptly appealed to the Supreme Court. Representing the bank was Daniel Webster, a brilliant and eloquent attorney who argued 168 cases before the Supreme Court, more than any attorney before or since. Representing the state of Maryland was the capable, articulate Luther Martin. Webster's argument embraced Alexander Hamilton's claim that Congress had power under the Constitution to make all laws which shall be necessary and proper to execute its enumerated powers under the necessary and proper clause of the Constitution. Since the enumerated powers in the Constitution included those of collecting taxes, borrowing money on the national credit, and maintaining an army and navy, Hamilton had asserted that establishing a national bank had a more or less direct relationship to these powers and was therefore within the intent of the necessary and proper clause. Daniel Webster, a member of the Federalist Party, repeated Hamilton's position to the Supreme Court, knowing that John Marshall, also a Federalist, agreed with this line of reasoning. Luther Martin made a brilliant and impassioned argument for the state of Maryland. He answered Webster by quoting John Marshall's own words to the Virginia Convention that ratified the Constitution back in 1788. John Marshall had argued 3 decades earlier that the Constitution should be ratified by the Virginia government because the federal government could not go beyond the powers specifically enumerated. But now that John Marshall was part of the federal government, he did not think limiting federal power was such a great idea anymore. Marshall wrote for a unanimous court in McCulloch in ruling Congress had power to charter a national bank. Marshall wrote, that while the Constitution does not specifically give the federal government the power to establish a national bank, it can be deduced from those powers that were enumerated in the Constitution. Marshall put his interpretation of the necessary and proper clause into sweeping terms, which have been quoted in dozens of later Supreme Court decisions. First, let's take a quick look at that clause, which is found in Article 1. The necessary and proper clause. It says this: "The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers." Now listen to Marshall's powerful words interpreting this clause. He says, "Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional." Almost as an afterthought, Marshall turned to the issue of taxing the bank. He said that states could not destroy through taxation the powers of Congress. Marshall summed it all up with these emphatic words: that the power to tax involves the power to destroy is a proposition not to be denied. In several ways, this decision was even more significant than the one in Marbury. The Marbury decision stated a principle which had evolved in law, though it was not specifically stated in the Constitution. McCulloch used the necessary and proper clause to deduce powers for the federal government, thereby expanding power in the federal government and limiting the power of states. This decision, along with many other factors, continued our collision course toward the American Civil War, which exploded 42 years later. Our next case is another Marshall Court decision, Gibbons versus Ogden, which addresses the interstate commerce clause of the Constitution.